Our next speaker is Dr. Camille GOODMAN. Dr. GOODMAN joined the Australian National Centre for Ocean Resources and Security at the University of Wollongong in March 2001. She is also a visiting fellow at the Australian National University College of Law, where she completed her PhD in January 2019. From 2005 to 2020, Dr. Camille GOODMAN worked in the Office of the International Law at the Commonwealth Attorney General's Department. From 2010 to 2012, she was seconded to the International Fisheries team at the Department of Agriculture. In these roles, Dr. Camille GOODMAN served as the Australian government legal advisor at the international meetings, advised on the implementation of international law, and managed litigations before international courts and tribunals. Dr. GOODMAN is the Deputy Editor of Ocean Development and International Law, an active member of Australian and New Zealand Society of International Law. Dr. Camille is an author. Her first book, titled Coastal State Jurisdiction over Living Resources in the Exclusive Economic Zone, was published by Oxford University Press in November 2021. Without much ado, Dr. Camille GOODMAN, you have the floor.
I'd like to start by offering my sincere gratitude for the extremely warm and generous hospitality of our hosts and the very thoughtful arrangements that they've made for this wonderful event. It's a great honour to have the opportunity to participate in this conference, exchange ideas with the preeminent experts in our field, and to spend time considering the important theme of this conference, 30 years of UNCLOS, then, now, and the future. So thank you for the invitation, and I hope that I can contribute in a small way to this extremely timely discussion. Then, now, and in the future, the beating heart of the 1982 United Nations Convention on the Law of the Sea is its role in balancing the interests of all states. Nowhere is this more true or more important than in the regime for the EEZ. The balance of interests features prominently in almost every discussion about the EEZ. It lies at the heart of the compromise described in Part 5 of the Convention. It's invoked in literature and jurisprudence to characterise and define the legal regime that applies in an area covering 1/3 of the world's oceans. And it's relied on by states to underpin arguments in support of both the attribution and the limitation of jurisdiction in the EEZ. And yet the Convention itself makes no specific reference to the concept of a balance of interests in the EEZ, let alone the process for achieving that balance. Given the critical role of the balance of interests in achieving and maintaining the grand bargain embodied in the EEZ regime, then, now, and in the future, my presentation today will focus on understanding this ubiquitous but elusive concept. In essence, what I'm asking is, what is the balance of interests in the EEZ, and how do we find it? In this respect, I'm taking some inspiration from my favourite Australian film, The Castle. This is a comedy that centres around a stereotypical hard-working Aussie family who are fighting to keep their modest home next to Melbourne Airport from being acquired by the government for airport expansion. They are represented by a well-meaning but incompetent lawyer called Dennis Denuto, who is completely out of his depth. In one of the movie's most famous scenes, Dennis is attempting to argue against the compulsory acquisition of the family's home. But he doesn't have any real knowledge of the relevant law. And when the judge asks him what his argument is, he resorts to saying, "It's the law, it's justice, it's the vibe." This has become an iconic phrase in Australian culture because it highlights the idea of legal arguments being based on a feeling or a sense of what is right, rather than on solid legal grounds, and perhaps because it pokes fun at lawyers. But it's also a useful way to underline the relevance of my question about the balance of interests. We all know what the balance of interests is. We probably have a feeling about what is right or just, but could we explain it in legal terms? So, what is the balance of interests in the EEZ? At face value, this is a simple question. The legal regime for the EEZ is achieved through a balance between the exclusive interests of coastal states, reflected in their sovereign rights and associated jurisdiction pursuant to Article 56, and the inclusive interests of other states, reflected in freedoms of navigation, overflight, laying of cables and pipelines, and other internationally lawful uses of the sea under Article 58. But the simplicity of this framework belies some complexities. Which interests are relevant to this balance? By what process are they to be balanced? And what might it look like in practice? Is the balance fixed, or does it change over time? Let's take these questions one at a time, considering then, now, and the future. The first question: which interests are to be balanced in the EEZ? We've had a lot of quotes from favourite authors today. I'm fond of a much quoted statement from the first president of UNCLOS 3, that dispute settlement procedures will be the pivot upon which the delicate equilibrium of the compromise must be balanced. Otherwise, the compromise will disintegrate rapidly and permanently. So I thought the best place to find the answer to this question would be in the jurisprudence of international courts and tribunals, appointed under Part 15 to carry out this pivotal role. I want to highlight 4 waypoints in the jurisprudence that I think help to show how our collective approach to this question has evolved from then to now. The first waypoint reflects one of the earliest themes in the jurisprudence of ICLS, described by Judge Haidar this morning: procedures for the prompt release of fishing vessels and their crews. Over the course of its first decade, from Saiga No. 1 in 1997 to Tomimaru in 2007, the question of how the balance of interests in the EEZ should be applied in the context of prompt release procedures was a recurring theme in the work of the tribunal. While the balance of interests required by Article 73, together with Article 292, is mentioned in some fashion in each of the prompt release cases considered by ICLS, the formulation presented in the Monte Conferco case in 2000 became the general point of reference on the balance of interest in subsequent cases. As formulated in Monte Conferco, Article 73 identifies 2 interests: the interest of the coastal state to take appropriate measures as may be necessary to ensure compliance with the laws and regulations adopted by it, on the one hand, and the interest of the flag state in securing prompt release of its vessels and their crews from detention, on the other. It strikes a fair balance between the 2 interests. This formulation is noticeably binary and specific. There are 2 relevant interests to be balanced in the context of prompt release, and they are both in the nature of rights: rights to ensure compliance with laws and regulations, and rights to secure the release of vessels and crews. This approach to the balancing of coastal and flag state interests under Article 73 has been subject to some criticism, as inappropriately favouring flag states and as failing to consider the proper context of the EEZ regime. In particular, the fact that both coastal and flag states have duties as well as rights, which are relevant to the way in which this balance should be struck. Apologies. The tribunal was specifically invited to consider some of these broader contextual issues in the 2004 Volga case, in which Australia, as the respondent, argued that the imposition of non-financial conditions as part of a bond was necessary in order to effectively combat IUU fishing in the Southern Ocean. While the tribunal acknowledged the need to have regard to all the circumstances of the case and took note of the significant international concerns about IUU fishing, it nonetheless adhered to the balance of interests as formulated in Monte Conferco. As an Australian, I must note that a dissenting opinion was issued by Judge Ad Hoc Shearer, with whom Judge Anderson agreed, which called into question the idea that the balance to be achieved in the EEZ should be preserved exactly as it was conceived at the time of UNCLOS 3, and suggested that in the context of fishing, and in the light of the challenges presented by unscrupulous operators and ineffective flag state control, changing circumstances required a new balance to be struck between vessel owners, operators and fishing companies on the one hand, and coastal states on the other. While I'm not sure that owners and operators should necessarily be part of this balance, I think Judge Shearer was right in trying to provide a broader formulation of the interests that require consideration, and perhaps he was just 10 years ahead of his time. Let's stay with ICLS and with fishing, but jump forward 10 years. to the 2014 decision in the Virginia G case, also mentioned by Judge Hyder this morning, and the 2015 request for an advisory opinion submitted by the Sub-Regional Fisheries Commission. These cases dealt with different legal questions, which raised the balance of interests in different ways, but both of them opened the door to considering not only rights but duties as part of the balance of interests. As Judge Hyder reminded us this morning, in Virginia G, the tribunal was required to balance the coastal state's exclusive sovereign rights over living resources with the freedom of navigation of all states in order to decide whether fishing-related activities, such as bunkering, fall within the jurisdiction of the coastal state or the freedom of flag states. The tribunal did not spell out its balancing process in detail, and it focused primarily on determining the extent of coastal state rights, rather than the balance to be achieved between coastal and flag states. But importantly, it touched on the idea that the coastal states' interests include not only the rights in Article 56, but the related conservation and management provisions in Article 61 of the Convention, which are essentially duties. A more detailed balancing process was also described in a separate opinion of Judge Peck, as he considered whether or not the confiscation of Virginia G was necessary in the sense of Article 73(1). Judge Peck noted specifically that the elaborate balance between the rights and the obligations of the coastal state and those of other states is at the core of the legal regime of the EEZ. He gave serious weight to the challenges experienced by the coastal state in enforcing its fisheries legislation effectively, and he also acknowledged the potential for various coastal state enforcement actions to burden the freedom of navigation for flag states in a way that would upset the balance of interests. These ideas are also reflected, in a different way, in the SRFC advisory opinion. Once again, the decision does not specifically refer to the balance of interests or describe a process of balancing, but it does specifically recognise both the rights and the obligations of coastal and flag states. In particular, it recognises that the Convention approaches the issue of conservation and management of living resources from the perspective of obligations of the coastal state, and that these obligations entail corresponding rights. This decision recalls the responsibility of coastal states to ensure the conservation and management of living resources in the EEZ, and it confirms that in light of the special rights and responsibilities assigned to the coastal state in the EEZ, it has the primary responsibility for taking measures to address IUU fishing. It also recognises the general and specific obligations of flag states in this regard, spelt out by reference to the duty of flag state responsibility in Articles 92 and 94. So these cases move beyond the binary and rights-focused approach of the prompt release cases, and they endorse the balancing of a fuller range of interests, not just rights or entitlements, but obligations or responsibilities or duties. This may seem obvious, particularly given the rule of reciprocal due regard in Article 56 and 58. But in the absence of an explicit process for balancing interests in the EEZ, recognition that both rights and duties are relevant to establishing the balance is critical, including to ensure that the ceiling placed on the state's rights is interpreted in a way that keeps it above the floor of states' duties, to steal from Alex Mills. In other words, to ensure that the rights of the coastal or flag state are not interpreted so restrictively as to impede the fulfilment of its obligations, and vice versa. I think this is an important distinction between the rights-focused approach taken in the early cases and the more comprehensive approach of these later fisheries cases. But the balance of interests in the EEZ is not limited to fisheries. Another significant contribution was made by the Annex 7 Tribunal in the 2014 Arctic Sunrise Arbitration. In this case, the Tribunal was effectively asked to consider the balance between coastal state sovereign rights over non-living resources and the freedom of foreign nationals and foreign vessels to conduct protest actions at sea. In this respect, the Tribunal found that the coastal state's sovereign rights legitimately extend to taking measures of protection or prevention, provided that those measures do not infringe or unjustifiably interfere with the navigation and other rights and freedoms of flag states. As in other cases, the decision does not explicitly refer to the balance of interests, but the Tribunal specifically and usefully provided that it would be reasonable for a coastal state to act to prevent violations of its laws adopted in conformity with the Convention, dangerous situations that can result in injuries and damage, negative environmental consequences, and delay or interruption in essential operations. The tribunal described all of these things as legitimate interests of coastal states, but also provided some outer limits by specifically noting that coastal states should tolerate some level of nuisance so long as it does not amount to an interference with the exercise of sovereign rights. So this case goes another step further than the rights and duties framing and demonstrates there's this broader category of legitimate interests derived from the rights and duties of coastal and flag states. What is this interest? How do we define it? Perhaps one way to think about it is that if rights are things we may do and duties are things we must do or we must not do, perhaps interests are the things that affect our rights and duties. Do they affect what we may do or what we must or must not do? The final case I want to touch on is the 2015 Chagos arbitration, which was also raised by Professor Davenport in the previous session. In contrast to previous cases, this decision did refer specifically to the balance of interests, but with a focus not on fisheries or oil and gas, but on the declaration of a marine protected area, and not on the extent of coastal state sovereign rights, but on the requirements of coastal state duties, specifically the duty of due regard under Article 56(2). In this context, while declining to find any universal rule of conduct, the tribunal set out a clear process for determining the extent of the regard required by the Convention. Pursuant to this process, the extent of the regard required will depend on the nature and importance of the rights held by the flag state, the nature and importance of the activities contemplated by the coastal state, the extent of the anticipated impairment to the flag state's rights, and the availability of alternative approaches. The tribunal also noted that in the majority of cases, assessing the outcome of this process will necessarily involve at least some consultation with the rights-holding state. So this is effectively a balancing process, and it can apply to coastal and flag states pretty much interchangeably given the reciprocal nature of due regard. So from this approach, I take inspiration for a general process which involves assessing and weighing the nature, importance and impairment that any particular action will have on the rights and the duties and the legitimate interests of all relevant states, and considering whether there are any available alternatives. Having started with then and reviewed the jurisprudence to determine which interests are to be balanced in the EEZ, we find ourselves now facing the challenge of enunciating a consistent or at least reasonably coherent process that can be followed for actually balancing those interests. To do this, I'm going to combine the various elements established from the jurisprudence and propose a three-step framework that states or tribunals or commentators could use to assess where the balance of interests might lie in relation to different issues in the EEZ. And in the tradition of speakers from the previous panel, you might like to think of this as a thought experiment. The first step is to consider what effect any given jurisdictional assertion, a measure or action, might have in the context of the relationship between the coastal state's own rights and duties. So this is a binary, but not in the sense of the prompt release cases. The purpose of this binary is to assess the nature and importance of the coastal state's rights, things that the coastal state may do, including any legitimate interests that might affect the exercise of those rights, and equally, the nature and importance of its duties, things that it must do or must not do, as well as any potential impairments to those rights and those duties. The reason for starting with this balance is to ensure that the coastal state's rights are not interpreted so restrictively as to prevent it from fulfilling its obligations, or indeed that its duties are not interpreted so onerously as to prevent the enjoyment of its rights. For example, noting the statement in the SRFC advisory opinion that the coastal state has the primary responsibility to prevent, deter and eliminate IUU fishing in the EEZ, it would arguably be relevant to make sure that its rights are interpreted sufficiently broadly to allow it to take relevant measures in relation to IUU vessels. The second step is to undertake a similar exercise with respect to the rights and duties of other states. And here I would say most importantly that means any relevant flag states, or one if there's one particular flag state, but also any other states, given that the measure or action may affect multiple states, or even potentially all states in terms of its precedential effect. So in this case, we consider the nature and importance of the rights of other states, the things they may do and their legitimate interests, and equally the nature and importance of their duties, the things they are obliged to do or refrain from doing. And we need to consider any potential impairments to those rights or duties that might result from the proposed action. Finally, the outcome of these two considerations needs to be balanced against each other in the way suggested in the Chagos arbitration. At this point, some other X factors may also come into play, depending on the particular type of balancing exercise and the jurisdictional assertion in question. In some situations, this will involve the consideration of alternative options to see if there's something else which has less impact on the interests of other states. And in some situations, it will, as the Chagos Tribunal identified, require consultation. In other situations, it might be relevant to consider the broader context, including the circumstances and manner in which the action or measure is proposed or was taken, as suggested by Judge Peck in Virginia G, or even the interests of the international community as a whole. Now, at this point, it's important to note that, as in the Chagos arbitration, this is not intended as a universal rule of conduct. And in the application of this test, and in the weighing of the balance, reasonable minds may differ. There's no completely objective way to ascertain which right or duty is more important, or to predict exactly how they may be affected. But that's why we have courts and tribunals. And this might at least provide a consistent and reasonably predictable process for states in making such decisions, and a way to ensure that all relevant rights and interests are taken into account. So finally, let's look to the future and consider what the implementation of this framework might look like in practice. I want to use an example which was actually raised by Professor Giraudot, but has not so far been the focus of much discussion and is about to become highly relevant: the regulation of navigation in and around offshore wind farms. So why is this relevant? In 2013, there was just 7 gigawatts of installed offshore wind in the world. In 3 years, this had doubled to 14 gigawatts, and in another 3, it had doubled again to 28. By the end of 2022, 63 gigawatts of offshore wind had been installed worldwide, and this trend is set to continue. In order to achieve net zero emissions by 2050, we need to install 2,000 gigawatts of offshore wind. This will require a further 32 times the amount of generation capacity currently installed, 3,200%. To fulfil this, we will need approximately 200,000 wind turbines, which will require approximately 500,000 square kilometres of ocean. So we're talking about some very large areas. This is going to require us to think about how we balance the interests of coastal states and other states, and of individual vessels, and of the international community as a whole, in areas where offshore wind turbines and navigation intersect. Obviously, there are an almost infinite number of specific jurisdictional assertions that we could weigh up here, but for simplicity, I want to think generally about what's involved in balancing the interests of coastal and other states in respect of offshore wind farms and navigation, using the framework just developed. Start with the coastal states' interests. The coastal states' rights are sovereign and exclusive in nature. They include the rights to exploit offshore wind resources, to regulate offshore structures and establish safety zones, and to prevent pollution. And they extend to interests in preventing interference with those rights. These rights are important because they relate to critical maritime infrastructure, which will be key to the coastal state's energy and economic security, and thus its national security, and to the renewable energy transition. They're also important to protecting the marine environment, which is a matter of both intrinsic and economic importance. On the other side of the ledger, the coastal state has a combination of general duties, like the duty of due regard and marine environmental protection, and more specific duties, like the requirement to give due notice of structures and safety zones, prevent, reduce and control pollution, and tolerate some level of nuisance in relation to its protected rights. These are important duties. They're central to preserving the protected rights of other states and underpin the fundamental freedoms of communication, as well as the safety of life and property, and once again, the protection of the marine environment. It's a bit difficult to predict the extent of the likely impairment to these rights, or to the coastal state's ability to fulfil these duties without actually considering the nature of the specific action or measure proposed or challenged. For example, The consideration would be different if the coastal state were proposing to prohibit all navigation through a 700 square kilometre wind farm, the size of Australia's largest offshore wind farms under our legislation, than if it is proposing to limit transit to certain vessels under specific conditions. But in general, the likely impairments are remarkably similar, whether they are considered by reference to rights or duties. Essentially, restrictions on the coastal state's discretion are likely to make it harder to locate, establish and operate wind farms and regulate navigation in and around them in the most effective, efficient and environmentally responsible way, which will lead to higher energy costs and potentially economic and environmental damage. A similar exercise can be conducted with respect to other states. This most obviously involves other states in their role as flag states, whether because they have a direct interest in vessels sailing in that area or because of concern about the precedent this might set for other areas. But other states also have other roles, including as consumers of energy produced and exported by the coastal state through cables, and as members of the international community with concerns about the marine environment, the energy transition, or even the costs of shipping. At a basic level, the protected rights of other states in this situation include freedom of navigation and related freedoms in Article 58, including the right to protest identified in Arctic Sunrise. The freedom from interference with use of sea lanes essential to international navigation in Article 60, and the exclusive right to exercise jurisdiction over vessels. Some of these rights are closely related to the coastal state's duties, and they're important for the same reasons. They underpin fundamental freedoms of communication and safety of life and property. But there's an added issue for other states that relates to the efficiency of navigation in terms of time, economic cost, and even environmental cost in terms of emissions. Of course, the duties of other states are established a little bit differently to those of coastal states. They share the reciprocal duty of due regard and the duty to prevent pollution, but they must also comply with coastal state laws and respect safety zones and navigation rules established by the coastal state, and they have to exercise their flag state responsibilities effectively. Again, the potential impairment to the interests of other states is difficult to assess without a specific regulation in mind, but in general, they're likely to include increased costs, decreased profits and higher emissions as a result of navigation being routed around wind farms, or potentially danger to life and property and increased insurance costs if navigation is exposed to more risk within wind farms. Either way, it could be more expensive. So what does it look like to balance these interests against each other in the third stage of the process? I was a bit surprised in summarising these rights and duties to find that coastal and other states had more common or overlapping interests than I expected. In particular, the inevitable balance between sovereign rights and flag state freedoms, which arise as rights and duties on both sides, the protection of the marine environment, and the safety of life and property. This also reveals some outlying interests which are important to take into account. In the case of coastal states, interests associated with protecting critical infrastructure and the production of renewable energy, and in the case of other states, the efficiency of navigation and the potential for higher shipping costs. And there are also a range of X factors which could be considered as part of the process, depending on the action or measure in question and who is doing the balancing. So to return to my question, what is the balance of interests in the EZ? I think it is law and justice and the vibe, but I think it can also be considered in a more systematic way. It's important to acknowledge that this approach might not be appropriate in all situations, and it's not intended as a universal rule or a universal ruler of conduct, but as a flexible framework to ensure that all relevant perspectives can be considered. It can be applied in a differentiated way, depending on the subject matter and the nature of the measure, action or assertion in relation to which balancing is needed. Importantly, the balance of interest is not binary, but three-dimensional. It includes rights and duties and legitimate interests of coastal states, flag states and other states. And it's comprehensive. It requires consideration of the nature and importance of those rights, duties and interests, as well as potential impairments to them, and leaves room for some consideration of relevant X factors. And as the examination of the case law and the little case study have shown, the balance of interest is not fixed, but develops over time in light of social, economic, political and geographic change, and advances in science and technology. So this is a balance that will need to be struck repeatedly and not always in the same place. The sort of process I've suggested is probably something that's done largely behind the scenes, on a whiteboard by officials developing a policy or law, by two states, or by a conciliation commission in the context of a negotiation or conciliation over a sticky problem, or by a judge as part of the process of analysing and weighing the arguments and evidence presented in a case. Clearly, this framework is not a silver bullet or a complete solution, but even if it is only used as a theoretical starting point in any of these cases, it could help to provide a fulsome process for balancing the interests of not only coastal and flag states, but all states, in a way that helps to preserve the compromises embedded in the Convention. Thank you.
Thank you, Dr. Goodman, for that insightful presentation.